Hello and welcome dear learners to the NPTEL course on Healthcare Quality Management, Infection Control and Patient Safety. In the Module 5, Operational Excellence in Healthcare, for the Chapter 55, Medico-Legal Aspects of Hospital Functioning, we will be discussing today about the legal requirements of a hospital, the concept of consent and confidentiality, doctors and arrest, prevention steps to avoid mitigation, statutory aspects of healthcare organization. So, for the legal requirements of a hospital, as you all know, hospitals are also known as in healthcare organizations. So, over the past decades, after the enactment of the Consumer Protection Act 1986, that is called as COPRA Act, the medical profession and institutions became legally accountable. Speedy legal processes under the medical negligence have increased litigation against the doctors and hospitals, where we find that the new amendment in 219 has made it more visible even for e-commerce and e-litigations. Key legal aspects of hospitals and doctors must address, which includes right of the patient under the Consumer Protection Act, even the consent, confidentiality, doctors and arrest, and prevention of litigation. This makes us more visible towards the patient through an hospitals and a doctor. Rights of the patient under the Consumer Protection Act. If you see the patient as a consumer, the patient has a right to information about the services which are rendered by the hospital. Patient goes to a hospital to get a services. So hospital need to be transparent regarding the availability of services, non-availability of the services, even the services offered on a particular day. All the information must be shared with the consumer or a patient. Patient must be informed about the cost of services. It is the right of the patient to be informed of the range of services, even the exercise free choice of services also. So if you find there are charters of the patients where the patient's rights and responsibilities are also stated, and which gives us the consumer, the patient, as the full right to get its power and get its services. So no monopoly over the services to be seen by the patient. For example, if a patient seeks an ENT opinion, all doctors in that specialty must be informed of the patient so that the patient can choose one among them. Patient choice and grievance redressal. Nowadays, we see a lot of litigations which are filed against the medical professionals. The reason is that patient exercises the right to choose services. The tariff variation must be disclosed so the patient can select accordingly. And if the patient finds that there is a problem with these issues, the patient may go for litigation to the medical professionals. Patient have a full right to grievance redressal. And hospital must have a help desk or a grievance officer to take care of this issue. The mechanism to entertain complaints and provide redressal to these issues. So, if we see into the duties of the doctor towards the patient, what a doctor or a medical professional needs to take care of. A doctor must exercise care to avoid monopolistic or restrictive trade practices. Patient must be informed about the benefits, the risk and limitations of the services that are offered. Patient have the right to education regarding the disease and the type of treatment, which is very important into the current times. Education can be provided through display, pamphlet and brochure, where the patient or patient's relative can get enough knowledge before they get the services. Now, with respect to the consent, we have to talk about and what is consent as a concept and how it is connected with confidentiality. The principle of consent. The consent principles are clearly depicted in Supreme Court of India judgments. Consent is a legal safeguard for both patients and a doctor. So it can be seen as a both a way of a communication. Any procedure performed without valid consent may attract civility or criminal liability. There are many landmark case laws which can be seen through Supreme Court and High Court judgment which have highlighted the issue of consent. The very popular Samira Kohli versus Prabha Manchandan as a doctor and ANR Supreme Court verdict which is decided on 16th January 2008. Let me put the facts to you. Let me see that this case is more towards the consent and confidentiality part, which is discussed through a patient who consented to a diagnostic procedure and a minor operative procedure. While under anesthesia in the unconscious state, the consent was taken. The doctor obtained a proxy consent from the patient's mother for a hysterectomy. The hysterectomy was performed without the patient's prior consent, which was very important according to the laws. And what happened? We can see that the Supreme Court of India rulings were being seen in this way. The consent obtained during anesthesia was found to be invalid. Consent must be real, valid, and informed. It should be informed to the patient. If the patient is an adult, consent must be taken directly from the patient and not into the cases of pediatric patient or those who are identified as minor. So proxy consent is allowed only in certain situations where the patient is mentally sound, where the patient is unconscious. Only in these two situations where the mentally unsoundness and unconsciousness is one reason where the proxy consent can be seen. The medical professionals, the doctor must avoid presumptive consent. Explain the procedure before anesthesia. Obtain a written consent. Not rely on convenience, personal judgment, and family pressure to continue the services. A detailed consent requirement is very important. So, a consent is being seen as a procedure specific. I can give you an example over here where it is said that a consent for diagnostic laparoscopy followed by consent for hysterectomy, where it is first moved with the procedure and it is more aligned actually to the diagnostic part, where it can be seen that the purpose is specified over here and that can lead to even hysterectomy in cases if it has to be done. If an additional procedure is required, a fresh consent must be obtained without failure. What are the exceptions for the consent? Life-threatening emergencies where delay could be a fatal to the patient, so the principle of necessity is being followed. What is principles of necessity stating as? It is stating as that when a patient is in a life-threatening emergency, without delay, the medical professional should continue with the procedures. It may be surgery, it may be diagnostics, or it may be even transfer of a patient to an ICU. So they can start with the procedure and the consent can be taken later. Diagnostic procedure, that is called as endoscopy or laparotomy. In those situations also, when you have to have a removal of organs and performance of procedure without consent, it is equally to tort. This can lead to a civil liability and a compensation claims, which nowadays we can see that a lot of patients or patients' relatives are putting towards the medical professionals. Consent includes procedure, benefits, risk, alternatives, and consequences of refusal. So if you find that there is no consent being sought, actually it may lead to lot of problems actually to the medical professionals. Explanation must be given in a language understood by the patient, where it can be followed with some sort of mediation. Consent must be signed by the patient and must have the signature of the impartial witness. Principle of necessity. The consent may be waived in emergencies to save the life of the patient. So, additional consent needed if procedure changes during the surgery, or you may find that the surgery has to be followed by some level of investigation, or in additional consent if needed is even in life-saving condition not present. What is confidentiality, which is connected over here? We will try to understand the confidentiality part actually, which is more dealing to the medical professionals. There is this right to confidentiality. Every patient has a right to confidentiality during the doctor-patient relationship, which is very important to be seen into the healthcare organizations. Any information disclosed by the patient during the history taking, clinical examination, investigation, diagnosis, treatment must not be revealed to any third party. It may be even the parents, it may be the spouse or any family member, because it is a very important information and it should be protected under the right to confidentiality. Confidentiality is the core ethical and legal obligation of the healthcare professional. It should be very well understood that confidentiality need not to be compromised. Is confidentiality absolute? It's a bigger question. What is the answer to this? The right to confidentiality is not absolute. So there is a turn over here now for this discussion. It has been seen that though the confidentiality are legally recognized in terms exceptions where disclosure is permitted or required. In certain situations where you find with the help of law when it is needed, you can also see that it is not absolute. So confidentiality may be breached, yes, under the orders of court of law. When the law has stated that it should be breached, confidentiality is one thing to be seen over here under the rules of law. Confidentiality may be breached when non-disclosure poses a serious risk to the life or to public health, where it is into the benefit of more larger health of an other person actually or a public health, then you may see that confidentiality may be breached. Even in a situation when disclosure is necessary to protect unidentifiable individuals from harm. If a person is getting a harm from another person actually, and when there is an issue of confidentiality with respect to disclosure of some reports, then it is very important the confidentiality may be breached under the orders of court of law. Now we will discuss one case actually which has been seen a very popular case, and we see the Supreme Court judgment for that. It was identified that Mr. X versus Hospital Z, a case in 2003, where the facts of the case can be put as the complainant Mr. X was admitted to a hospital for a treatment. He has routinely gone through the admission process, and during the medical investigation, he was diagnosed as HIV positive. What should the hospital authority do? The hospital authority disclosed his HIV status to his fiancée, who is intended to be marrying him and has been identified as a spouse actually in the coming days. So as a resultant, his marriage proposal was cancelled and he faced a social stigma. The girl has gone against and she cancelled marriage. Mr. X filed a petition claiming that there is a breach of confidentiality from the healthcare institution, violation of his right to privacy of not disclosing his disease condition. Also, he has put into his petition the mental agony and reputational damage that he has faced. If you see on the side of Mr. X, he has claimed it rightly. But if in the eyes of the law, actually what the case is reflected as. The key legal issues before the court were where a hospital or a doctor is legally justified in disclosing a patient's HIV status without consent, where the right to confidentiality and privacy overrides over here. The right to life and safety of another individual is one very important, where right to life is more important than the right to confidentiality. Now, what did Supreme Court of India give? Supreme Court of India has given a judgment with respect to the observations which are stated over here. It was seen that Mr. X HIV condition is a serious thing and is a life-threatening condition. The intended spouse, the girl, was at a high risk of exposure to this disease condition. So, with respect to that, the Supreme Court has given the observations. So, the non-disclosure could have resulted in serious harm to the spouse, irreversible consequences. So, the doctors have a duty to safeguard a person who may be exposed to the serious harm. So, in such situation, social interest outweighs the individual privacy. The social interest which was more towards the girl or the spouse or outweighs the individual privacy of Mr. X. And what did the final judgment came as? The final judgment was like disclosure of HIV status in this case was justified and lawful and in public interest. So it is very clear that disclosure of the HIV status was not purposely done by the physicians, medical professional, but it was only justified because they have given in favor to the girl because it could safeguard the person from the exposure to serious harm. The Supreme Court of India ruled the right to confidentiality over here. The right to confidentiality is overridden by the right to life of others. And right to life of others is very important compared to the right to confidentiality of an individual person. The petition was dismissed and hospital action was upheld as legally valid. Here, the hospital was being seen as freed and has to be found that it was more favor into the life of others. So with this, we can understand that how it is very important for the medical professionals to be very clear with respect to consent and confidentiality. What is the key principle established by this case and what are the learning? The learnings are confidentiality is important but not absolute. Disclosure of the confidentiality is permitted in certain situations. It is the situations where there is a serious risk to the identifiable individual. It is a serious risk where there is a threat to a public health. So doctor must keep a balance of patient privacy versus safety of others. It is very important that many times these challenges are to be found as difficult to handle. In such cases, we say a ethical duty extends beyond the individual patient in certain circumstances. So, the practical implications for hospitals and doctors over here are being seen that maintain confidentiality as a rule, but it cannot be obsolete. Disclosure information only when it is required by the law, and only when the law states by its order and necessary to prevent the serious harm, where you need to be protected yourself and you need to even maintain a confidentiality of the patient. Decisions to disclose should be well documented and it should be justifiable on legal and ethical grounds. If required, you can consult a legal professional. Hospital policies must clearly define the circumstances for lawful disclosure. Otherwise, your hospital and you may face a litigation by the patient. Now, in the case of doctor and arrest, this is something which can seen as a topic actually where you find lot of governing legal principles to be discussed. You can understand that criminal negligence of doctor is governed by Supreme Court of judgments. The Supreme Court judgment only can see and can lay down actually the criminal negligence of doctors. Not every medical error or adverse outcome amounts to be a criminal negligence. So you may find every moment in a medical practice is being seen as unprecedented situations. The law provides a specific protection to medical practitioners and it is against the unnecessary harassment. It has been seen that lot of the moment most of the complaints are being found to be as an harassment towards a medical professional. We can discuss the landmark judgment case of Supreme Court of India. A very popular case which has a lot of references into the medico-legal aspect is Jacob Matthew versus State of Punjab and others. That is the case in 2005 where the Supreme Court of India has given the judgment and which was found to be a landmark judgment. Let me put the facts of this case to you. A patient was suffering from terminal cancer and was under a treatment. It was seen that during his treatment the oxygen cylinder was found to be empty. And it was because the patient has been termed to be died actually. The situation seen into way that the patient was admitted, the patient was with high comorbidity and immunocompromised, the patient was in the last stage of cancer. There was a treatment where the requirement of oxygen was there and the oxygen cylinder was found to be empty and this has resulted the patient to die. What did the patient's relatives have done? The criminal complaint was filed against the doctor alleging a medical negligence. At the first sight, you may understand that this case how it has to be explored to understand what medical negligence is. The case raised an important question. When can a doctor be criminally prosecuted for negligence? Because this can be a case of a civil but not can be a case of criminal. And if you have to distinguish it, how you have to see the questions to be raised against this. What are the observations that Supreme Court of India has done? So Supreme Court of India with respect to this very popular case have given the observation on criminal negligence. Supreme Court of India clearly distinguished between the civil negligence and criminal negligence. The Supreme Court of India held that criminal negligence requires a very high degree of negligence. It is very important to state over here that very high degree of negligence is only one which is a requirement to be stated for a case for criminal negligence. Mere error of judgment, lack of success in treatment, and accident during treatment does not amount to criminal negligence. So this can be a citation to be seen as to all those cases which comes for medical negligence. That the case need to have a degree of negligence at a high amount. What are the degrees of proof that are required? For a case to be stated as criminal negligence, it must be proved beyond a reasonable doubts. There should not be any doubt and it should be a very clear case. This is much a higher standard than a civil negligence. Civil negligence is something a very different thing versus to a criminal negligence which is being seen in a very severe things. The burden of proof lies heavily on the complainant. A person who is doing a complaint and is being identified as a complainant need to prepare the proof to state it as a criminal negligence. So what is the role of police in the medical negligence cases? As we have been discussing a lot with respect to the medical negligence cases and with respect to Consumer Protection Act, it is very important that most of the judgment which may be coming to even a Consumer Protection Court or even through a regular court from High Court to Supreme Court of India, lot of clear instructions are given to the police. The police do not have medical knowledge. Police cannot decide on medical negligence on their own, and it is very important in this particular case to understand that in every point the police cannot be the one who can be seen as someone who has a medical knowledge. The police cannot decide the fate of the medical negligence on their own, and this is one of the reason that you cannot find the police can decide the decision for any of this act against the medical professionals. Police must obtain expert medical opinion, preferably from a competent doctor or a government medical institution. Only and only after that expert opinion confirms the gross negligence can be proceeded. So without this, the police by its own cannot take the decision. In what situation the arrest of the doctors can be seen? So Supreme Court of India has given guidelines for this. What are those guidelines? The doctor should not be arrested routinely and it should not be automatic after registration of a complaint. So it cannot be seen that someone will go for a complaint actually against a doctor to a police and the doctor will be arrested. It is not possible. Arrest is justified only when there is a gross medical negligence and rashness. So what is the reason that you can put it? It is more that there should be a strong evidence for that part. The evidence must be proof for the gross medical negligence. So routine arrest cause mental agony, loss of reputation and embarrassment to the doctors and can be seen against the medical fraternity. The court observed that many complaints lodged in the police stations are motivated, some are intended to extract money and harass doctors. Doctor must be protected from the frivolous and unjust complaints and it is the right of the country to see that doctors cannot be observed with such complaints which are being seen as the fraudulent complaints. What are the legal safeguards and criminal liability standards? There is a high threshold for liability and a doctor cannot be held criminally liable unless the negligence is being seen as gross and of a very high degree. So good faith protection. Physician acting in a good faith with reasonable care and skills are protected from the prosecution. recognizing that medicine is not an exact science. There may be or may not be in case of the treatment. Adverse outcomes and negligence. The law acknowledges that an adverse patient outcome or error in judgment does not automatically constitute for criminal negligence. So it has to be seen with respect to the degree of negligence. What are the safeguards against harassment? Strict legal guidelines are necessary before initiating actions because bail or eventual acquittal cannot undo the mental stress or loss of reputation that the doctor has gone through. These are the key types of civil negligence and criminal negligence. On the right hand side, we will find that mild inadvertence, lack of skill and judgment error are seen as civil negligence. On the other side, the civil negligence is being seen as a gross negligence and a recklessness. What are the common examples of criminal negligence? That is no qualification and doing the part, no referral, non-investigation, no valid consent and contraindicators. These are very important things that you can put the medical professional into the gross negligence part. Where versus on the other side where it can be seen as a civil negligence, actually breach of relationship, which is a very thin thread, failure of responsible or reasonable care. It can be sometimes that the damage can happen to the patient or an injury. So this is being seen as a civil negligence examples versus to on the right hand side actually you can see the common examples of criminal negligence. What are the steps of prevention to avoid the mitigation? The primary prevention and prevention for litigation and secondary prevention. In a primary prevention, it can be seen that it enhances the healthy relationship where the trust, faith and no harassment versus a clear communication if it is there with respect to diagnosis, prognosis and option relatives or a transparency with respect to continuous professional development, you may come across a preventive mechanism. Where versus on secondary mechanism, update the skills regularly which will avoid meeting actually these cases or proper documentation which will save with respect to investigation, treatment and advice and consent which is very important which must be documented and which avoids actually the assaults or vandalization. With respect to prevention of litigation, if at all it comes to a tertiary prevention where indemnity insurance and depend on the risk, it involves a lot of things. For a quaternary setups, actually we can understand that a strong legal and professional support with respect to risk management, safety measures and proper facility management is very important. So the precautions to be observed are stated over here from the process which are listed down over here can be seen over here. What are the statutory aspects and major acts for healthcare organization? You may come across to see major applicable acts to the hospitals are more from Indian Medical Council Act, Clinical Establishment Act, Biomedical Waste Management Act, Drugs and Cosmetic Act, Transplantation of Human Organ Act which is added more with the tissue part now it's the latest amendment, PCPNDT Act, ART Act and Blood Bank Regulation. Lot of labor laws and employment related acts are also there. With respect to environmental safety which is more concerning even to the health and healthcare organization also we have lot of acts. Even the statutory aspects of healthcare organization which it is very important needs to have a license, registration and it should fully comply with the results of fineness, suspension and even if at all it is not coming to comply the registration can also be cancelled actually. Now, with respect to this particular chapter, which is more dealing with the medico-legal aspect, and we will be continuing even the concluding next chapter also. And with this, I come an end to this discussion for this chapter. So, thank you for patience listening.